Okay, have you ever looked at a contract and just felt like completely overwhelmed
Right.
by all the legal jargon and the fine print,
Absolutely.
and you're just like, I need a lawyer to decipher this thing just to figure out what I'm actually agreeing to.
Yeah, especially when you realize like one little clause buried in there could have huge implications down the line.
Right, exactly.
That's what we're here to unpack.
Yeah, think of this deep dive as your shortcut to understanding what really matters in these really complex situations.
Yeah, today we're diving into a real-life legal battle that's all about how a contract was interpreted.
Ooh, juicy.
Yeah, and it's not just some theoretical legal stuff.
Mm-hmm.
It's a concrete example of how things can go wrong on a big project and how the fine print can determine who's actually responsible when that happens.
Right, because in the end, it all comes down to that piece of paper.
Exactly.
So for this deep dive, we're looking at a high court judgment. The case is Sisk versus Capital Centric.
Sounds kind of dry.
It does, but trust me, it's a good one.
All right, I'm intrigued.
So we've got John Sisk and Sun Limited. We'll call them Sisk for short.
Makes sense.
They were the contractor on this project.
Okay.
And then you've got Capital Centric Rose Limited, or CNC.
Right.
They were the developer.
Got it. So contractor versus developer.
Exactly. And the big question was, who was responsible for the existing structures at the site? It was called the Weir Mill site in Stockport.
Weir Mill. What kind of structures are we talking about here?
So we're talking about buildings that were already there on the site before any new construction work began.
Okay. So they're conditioned whether they could actually handle the new development?
Yeah.
That's what the disagreement was.
Precisely. That's the heart of it.
Yeah.
And this high court judgment that we're looking at, it's not just a bunch of legal mumbo-jumbo.
You know,
It actually goes into detail about the contract negotiations, the back and forth between the parties, and how the court interpreted the key clauses about who takes on the risks.
so it's like we're getting a behind-the-scenes look at this high-stakes deal gone wrong.
Yeah, exactly.
I'm ready to dive in.
So let's break it down. So to really understand why Sisk and CNC ended up in court, we need to go back to the contract itself.
Makes sense.
Now, they used a standard form contract, a JCT design and build contract from 2016.
Okay, JCT, that's pretty standard in the construction industry, right?
Absolutely. It's widely used, but almost always adapted for specific projects.
Right, because every project is different.
Exactly. And this case was no different. They had a lot of bespoke amendments.
Bespoke. So they really tailored it to this specific project.
Yes, and one of those amendments was a clarification clause dealing with risk allocation.
Ah, okay. And this becomes the center of the whole legal battle.
It does. Now, it's important to remember that before this high court case, there was already an adjudication.
So like a preliminary ruling.
Exactly, a faster way to try and resolve disputes in construction, and Sisk actually lost that first round.
Oh, so this high court case was the final word.
Exactly, this was the definitive judgment. So now let's get into the nitty-gritty of how the contract initially laid out who was responsible for what.
Okay, let's do it.
Clauses 2.42.1 through 2.42.3, these are the key ones here. And honestly, when you read these clauses initially, you might think that Sisk signed up to be responsible for almost anything and everything that could possibly go wrong on that site.
Really? They took on that much risk?
It seems that way at first. So these clauses really seem to put almost all the site-related risks squarely on Sisk's shoulders.
Like what kind of risks are we talking about specifically?
Well, this included the condition of any existing buildings or structures on the site,
Right.
and even the accuracy of information that CNC had provided about the site.
So if CNC gave them bad information, Sisk was still on the hook.
It seems that way from these clauses. It's almost as if CNC was saying, here's the site, you do your due diligence, because once we sign, you're responsible.
Wow, that's a lot of pressure.
Right, and the language in these clauses was very broad. For example, Clause 2.42.1 stated that the employer gives no warranty or representation as to the condition of the site, any existing buildings or structures.
So no guarantees whatsoever.
Exactly. And it went on to say that CNC wasn't guaranteeing the accuracy of things like soil data, asbestos reports, any of that.
So they were basically saying, we're giving you the information we have, but you're on your own to double check it.
Yeah, that's the gist of it. They were basically saying it's up to Sisk to verify everything and make sure it's all good.
And what about clause 2.42.2? How did that add to this whole risk allocation thing?
2.42.2, that one really drove the point home. It stated that Sisk was deemed to have inspected and examined the site and to have satisfied himself before the date of the contract as to the nature of the ground, the subsurface conditions, the existing buildings, structures, all of that.
So they were expected to do their own thorough investigation.
Absolutely. And the key part here is that any information CNC provided was by way of information only, without any warranty or representation as to its accuracy, reliability, or completeness.
So even if CNC gave them information, it was like, take it or leave it.
Right. It was basically on Sisk to do their homework.
And I'm guessing 2.42.3 didn't make things any easier for Sisk.
You guessed it. It added yet another layer, saying that Sisk acknowledges that it shall be solely responsible for ensuring that the ground, the site, and any existing structures to be retained are suitable for the development.
Solely responsible. It sounds like they were really putting all the burden on Sisk.
It does, right?
Mm.
And it even went as far as to say that Sisk wouldn't be entitled to any extra time or money if they ran into unexpected problems.
Wow, so they were really taking on a lot of unknowns.
Yes. At first glance, it seems like a really tough deal for Sisk. So one takeaway here is that contracts often try to front-load responsibility onto one party to make it very clear who's taking on what risk.
It makes sense to have that clarity up front,
Yeah,
but it seems a bit one-sided in this case.
it does. But here's where things get really interesting.
Oh, there's a twist.
There's a crucial qualification to all of this, a clause that really changes the game when it comes to this risk allocation.
Okay, I'm all ears.
Right? It's clause 2.42.4, and it states very simply, this clause, 2.42, shall be subject to item 2 of the clarifications.
Clarifications with a capital C. I'm sensing this is important.
You're absolutely right. It's a defined term within the contract itself.
So there's a specific meaning attached to it.
Exactly. The contract had its own definition of what these clarifications were. It defined them as the clarifications headed contract clarifications contained within Volume 2, Appendix 2.9 of the employer's requirements.
So a very specific document.
Very specific. Now, here's where things get a bit messy in the real world. It turns out there were actually 2 electronic documents floating around. One was clearly labeled contract clarifications, and another was called tender submission clarifications.
Yeah. 2
Yeah,
different sets of clarifications. That sounds like a recipe for confusion.
it was. And this is where a major part of the legal argument came up. Did that capital C clarifications in clause 2.42.4 refer to both of these documents?
Right.
Or just the one specifically titled contract clarifications?
So which document actually had the power to modify that broad risk allocation we talked about?
Yeah, exactly. This really shows how important precise language is in contracts.
Yeah, one little word can make all the difference.
So the judge in the high court case had to sort this out. And he very carefully looked at the exact wording in the contract definition.
Right.
And it specifically pointed to the document headed contract clarifications because of that precise language and that capital C.
Uh-huh.
The judge decided that only that specific worksheet, the one explicitly labeled contract clarifications, was actually part of the contract's definition of clarification.
So only that document could change clause 2.42.
Exactly. The tender submission clarifications, even though they were related to the project, they weren't formally part of the contract in the same way.
So a key takeaway here, I guess, is to always pay attention to defined terms in a contract.
Absolutely, because a little detail like capitalization can have big legal consequences.
That's all about the details.
It is. So with that settled, the court then focused on item 2 of this contract clarifications worksheet.
Okay. So what did that crucial item say?
Well, item 2 is set up in 2 columns, Sisk clarification and comments risk owner.
Right.
Under the Sisk clarification column, it stated, existing structures risk, including ability to support, facilitate proposed works.
Okay, so that's Sisk laying out their concern about the existing structures.
Exactly. And then in the other column, comments risk owner, it said, the employer is to ensure the existing buildings works. Employer also to obtain warranty from Arup with regard to the suitability of the proposed works, employer risk.
Okay, there's a lot to unpack there. Let's break it down.
Let's do it. So the first part mentions insurance.
Yeah.
The employer is to ensure the existing buildings works.
Okay, so CNC was responsible for the insurance.
Right, and the judgment points out that this aligns with insurance option C.1 of the standard JCT contract, which is a joint names policy.
So both parties are covered.
Exactly. But here's the thing, and the judge made this point, just because CNC had to get the insurance doesn't automatically mean they were taking on the risk of something happening to the structures themselves.
So it's more about who sets up the safety net, not necessarily who's ultimately responsible if something goes wrong.
Exactly. It's like having insurance on your car. You're responsible for driving safely, but the insurance is there if something happens.
Right. Makes sense.
Okay, so then the second part of item 2 talks about an Arup warranty. Now, Arup, as the judgment clarifies, they were the civil and structural engineers hired by CNC for pre-contract investigations.
Okay, so they were brought in early on.
Yes. And the clarification stated that CNC had to obtain warranty from Arup with regard to the suitability of the proposed works.
Okay, so a warranty from the engineers, but what exactly would that cover?
That's a good question, and the judgment actually highlights this ambiguity. It points out that it's pretty unusual for a firm like Arup to give a broad, unqualified warranty about the suitability of the proposed works at this stage.
Especially since the detailed design probably hadn't even been done yet.
Exactly. And their professional indemnity insurance typically covers them if they make a mistake due to negligence, but it doesn't usually guarantee a specific outcome.
Or cover pre-existing problems they weren't specifically asked to investigate.
Right. So the practical scope and benefit of this Arup warranty was kind of up in the air.
Okay, so some uncertainty there.
Definitely. But now we get to the really crucial part. Employer risk. Remember, those words are right there in the comments risk owner column immediately after the insurance and the Arup warranty.
Oh, yeah. That's pretty clear.
It is. And this was Sisk's main argument. They said that employer risk in this context meant that CNC would be responsible for the costs and any delays if the existing structures turn out to be unsuitable.
It does seem like a pretty straightforward interpretation.
Right. If it says employer risk, it's reasonable to assume the employer is taking on that risk.
So what did CNC say about that?
Well, they had a different perspective. And to understand their argument, we need to look at those tender submission clarifications that we talked about earlier.
The ones that weren't technically part of the contract.
Exactly. But they still give us some background on the negotiations.
Okay, so what do they tell us?
So these tender submission clarifications basically documented some of the initial discussions back and forth during the bidding process. Under a section called Design Responsibility, Sisk had initially proposed that existing structures risk sits with the employer, including insurance, and asked for a warranty from Arup.
So that was their opening position.
Yes, and CNC's response was very clear. They said, not accepted. We will categorically not accept a blanket exclusion on existing structures.
Wow. So they were really pushing back against taking on that risk.
Absolutely.
Yeah.
But later on in those same tender submission clarifications, it seems like things shifted a bit.
How so?
Well, it says that after a meeting, the agreed position was that the employer is to ensure the building's in line with JCT option C.
Which is what ended up in the contract clarifications.
Exactly.
Yeah.
So CNC was willing to handle the insurance, but they were initially very against taking on the broader existing structures risk.
Right. So the question is, why did the contract clarifications later include that phrase, employer risk, if they were so against it before?
Exactly. And CNC argued that their earlier stance in the tender submission clarifications should be considered by the court.
So they were trying to bring in those earlier discussions to influence how the contract was interpreted.
Yes, but the judge disagreed with that approach. He said that generally courts don't look at pre-contractual negotiations to determine the meaning of a final written agreement.
So what matters is what's in the final contract document.
Exactly. The idea is that the written contract is supposed to be the complete and final record of what the parties agreed to.
Makes sense. Otherwise, you could just argue about anything that was said during negotiations.
Yeah. There are some exceptions to this rule, like if there's a technical term everyone understood differently, or if there's a dispute about the overall purpose of the contract.
Okay, so there's some nuances.
Yes.
Yeah.
But just trying to use evidence of what each party meant during negotiations is usually not allowed. The focus is on the objective meaning of the words they actually used in the final document.
So what the words mean to a reasonable person.
Exactly. So the judge had to focus on the objective meaning of the words in the contract specifically, Clause 2.42 and Item 2 of the contract clarifications.
And what was his decision?
Well, the judge ultimately ruled in favor of Sisk. He concluded that CNC was solely responsible for the risk that the existing structures might be unsuitable.
Wow. So despite those initial clauses that seemed to put the risk on Sisk, that one phrase, employer risk, really tipped the scales.
It did. It carried a lot of weight legally. So let's break down how the judge got to that conclusion.
All right, I'm curious.
So firstly, he emphasized that Clause 2.4 specifically referred to Item 2 of the clarifications, and we already established that this meant the contract clarifications document.
Right.
Secondly, he said that the most natural way to interpret employer risk in this context was that CNC was accepting responsibility for the existing structures.
I mean, it does say employer risk pretty clearly.
Exactly. And he also reasoned that the requirement for CNC to get the insurance and the Arup warranty were things they would logically do if they were taking on that risk.
So those were seen as ways for CNC to manage the risk they had assumed.
Precisely. Plus, the judge pointed out that employer risk was used consistently throughout the other contract clarifications to mean that CNC was responsible.
So it was a pattern.
Yes, it was a pattern of how they were allocating risk in the contract.
Okay, what about those tender submission clarifications that showed CNC didn't want to take on the risk initially? Did those have any impact on the final judgment?
Well, the judge acknowledged them in the history they provided, but he didn't think they proved that CNC's final position was the same. He emphasized that contract terms often change during negotiations.
Which makes sense.
Yeah.
Things evolve.
Exactly. And the fact that they included clause 2.4 and that specific wording in the contract clarifications suggested that they had moved on from their initial position.
So the final agreement was what mattered.
Exactly. So what can we learn from all of this? What are the big takeaways for you?
Well, I think the biggest one is just how important it is to use clear and unambiguous language in contracts, especially when it comes to risk allocation.
Right, because one little word or even a capital letter can have huge consequences.
Exactly. And another key point is that standard contract clauses can be completely changed by specific clarifications or amendments.
So you can't just rely on the boilerplate language. You have to read everything carefully and understand how all the different parts fit together.
Absolutely. And we also saw how courts interpret contracts. They focus on the written words themselves and the context of the agreement, trying to understand what a reasonable person would think those words meant.
And a really crucial point is that generally you can't use discussions or emails from before the contract was signed to try and change the meaning of the final agreement.
Right. What matters is what's in writing in that final document.
Exactly. So to sum it all up, in the Sisk versus CNC case, even though some of the initial clauses seem to put most of the risk on the contractor, that one phrase, employer risk, in the contract clarifications was enough to shift the responsibility for the existing structures entirely onto the developer CNC.
That's a powerful reminder that the details really matter.
They do. So here's a thought for you after this deep dive. How might this case influence how you approach risk assessment and the language you use in your own projects or agreements, whether it's in construction or any other field?
It really makes you think about the importance of clarity and precision in any agreement.
It does, because even seemingly small things can have big consequences.
Exactly. So think about what questions this case raises for you about who's responsible for what in complex projects.
It's all about striking that balance of responsibility.
It is. And you might find it helpful to look into the JCT design and build contract more, or even just learn more about how courts interpret contracts in general.
It's always good to be informed.
Absolutely.
Well, thanks for joining us on this deep dive today.
My pleasure.
We hope it's given you some insights and some things to think about. Until next time.
See you then.